The line is often blurred between conduct that should be tolerated during a strike and conduct that amounts to misconduct, for which employees should be disciplined. Joining us now on whether there's a need for new code for disciplinary action during labour strikes is Lebogang Kutumela, a dispute advisor at the law firm Bowman, Gilfillan's Employment Law Department. Lebogang, thanks so much for your time. So we are heading into what is known as strike season in South Africa as labour and employers debate and negotiate wages in the new fiscal year. These strikes have often been characterized by a lot of violence. Why is that?
The issue really, if you look at it, is that when you're calling upon the unions to actually enter into the power play, the unions in a way have seem to have lost that that grip on the employer, and the unions not being able to bargain for perhaps what they traditionally were able to bargain for, happen to resort to violence and it resulting into misconduct.
Now, we have strikes defined in South Africa as protected and unprotected. What does that mean, particularly as you start to investigate issues of misconduct and violence?
The meaning is simply divided in terms of at least procedure, which is laid out in Section 64. Just a step backwards, the right to strike, as you rightfully said, comes from the Constitution itself. So it's a constitutional strike, but it's given effect to in terms of the Labour Relations Act, specifically Section 64 of the Labour Relations Act, which sets out, say, if you follow Section 64 procedures, then the strike is protected. If you don't follow the Section 64 procedure, then it is not protected, and therefore you've got two forms of strike in that event.
All right, usually what I read from what you're saying is protected means your right to strike is protected by the law, but your right to earn your income during that strike season is also protected by the law. Your behavior, is that protected within a protected strike?
Maybe let me just clarify it. Your right in terms of the law is protected for you to enter into the power play. So the no work, no play principle will still apply. However, you remain being an employee of the company, and you must behave in the manner in which an employee behaves towards its employer. So the only protection that is granted is the one in Section 67, the most important immunity being that you may not be dismissed for being in a protected strike.
Right, so when these strikes become unruly and striking workers start to intimidate non-striking workers, what's the recourse to law?
The recourse really is exactly the recourse which the employer has in the normal disciplinary processes. Your employee remains being your employee. An employee, even if he's in a protected strike, will remain being your employer. Therefore, if you are able to pick up anything which contravenes the rules of the trade, then you can be able to take a disciplinary inquiry at any time, even during the strike itself. So you look at the conduct. Is it conduct that is acceptable in light of what's going on in a strike action, or has the employee gone beyond the confines of the protection?
And what happens when we're not really dealing with the physical harm that we can induce on each other, but we start seeing damage to property, be it property associated with the employer or just
misconduct is as broad as the way it is. It is not really confined to the violence of you beating up another employee. It stretches to you damaging the property, you damaging the property of the company, be it the building or the vehicles, or even taking another employee even away from the workplace. So as soon as you can be able to see that this conduct would not be accepted in the normal event, misconduct being that you contravene a law or a procedure of the company, then you should be able to take disciplinary action.
How do you know that there's been misconduct? Often the media reports on it, but how do you know that Lerato in particular was involved with trashing a building by throwing stones at it or whatever the case may be?
The easier way really would have to be a person who maintains what we call a strike diary, or a person who has a video camera and actually looking and seeing what employees are doing. That's if it happens in the confines of the workplace. But if it doesn't happen in the confines of the workplace, as recently has been the case, that non-striking employees would be attacked at home, then you interview actually the victim, and you ask the victim. Victims will always know the perpetrators. They work with them. You ask the victim what happened, and you take the statement, and you take it from there.
What are you saying? So the moment your employers embark on industrial action, somebody from within the company must be out there not participating in the strike, but monitoring the conduct of striking workers.
A strike strategy is as important as your business will ever be. a person needs to come, the moment a strike notice is given, the employer needs to come up with a strike strategy which says, these are the rules which we are going to allow, called picketing rules, and this is the person or the people who are going to maintain what happens in the building. See exactly that people are behaving in order, and maintain that diary. If it means you taking the notes, that's the order of the day.
That's not going to make you very popular.
But that strike diary eventually is going to be very important, especially if you need to take disciplinary action against the employee.
Now, if I get beaten up in a strike, and I'm going to say touch wood to that, okay, my first port of call would be the South African Police Service, not internal lawyers or a legal team.
Yes, that might be your first port of call. However, you still have to come back to the place of employment, which makes it important for the employer to be able to take action against an employee who beat you up, touch wood, as you said. You need to still report it to the employee, because should you open your mouth and you don't tell your employer, that person will still continue to perpetrate the harm. So you can be able to use both processes. It's criminal on one act, on the one section, and it's civil on the other section, being labor law practices. So two laws regulate the separate actions.
Okay, punitive measures.
Yeah.
What punitive measures can be instituted once you're found guilty?
Punitive measures range from exactly what you can do to your employee who perpetrated the conduct in the employment, ranging from a written warning to even a dismissal. But each and every case has to be assessed on its own merit. But because violence is not protected, that one more often than not, it tends to attract a sanction of a dismissal. But dismissal is not automatic. One still needs to apply themselves to exactly what happened and the harm which was caused, and then come up with the appropriate sanction.
Right, so those are sort of the individuals you isolate as having been violent or behaving badly within the course of the industrial action. What happens to the negotiating process in itself? Because often employers are driven into a corner by this kind of behavior, and it introduces a kind of a tension in the negotiation process. Does it in any way give the workers an upper hand, or does it put them on the back foot? What does it do to the actual
The reality of a strike is that it's a power play. It has been designed exactly for that, to give an employee or the employees a right to have a go at the employer. The employer has the funds or has the job, says, I'm withholding the job. What do you have? Then you've got your labor, you're withholding the labor. A certain they can be condoned, the employees, by virtue of the realities of a strike. But as to how far you can be able to condone it, then it's up for the employer to really assess the case. So it is not, much as the strike is not a license for you to misconduct yourself. One still needs to look at, did the person step out of the realms of what is reasonable?
You've just answered me like a lawyer. That's lawyer speak. If I'm in a negotiation with you over wages, and you decide to trash my building, can I easily say to you, this negotiation is suspended until you rein in your workers, until you paint my walls, then we can have a civil conversation?
The negotiation cannot be suspended in that way. What I am saying is that one needs to appreciate that the employee in that context is a negotiator. And as a negotiator, it's going to require some forceful interactions. But one is not merely going to say, just because an employee upped and shouted at the employer, therefore it needs to be dismissed. It's a judgment call. Value judgment needs to be applied.